answer after we have this second question. Are the dangerous impact limited to expected risks or also extend to cover non-expected ones? Sometimes a doctor can expect risks, or there are expected risks that should be known to the doctor. But sometimes the risks are not expected. There is the possibility that the risks are not known to the doctor. In this case, how should the doctor act? What should the doctor do? Is the doctor under a duty to, question number one, to inform the patient of all impact of his illness? Question number two, is the doctor under a duty to inform the patient of expected and unexpected risks? Let me have an answer, please.
Doctor has duty to inform expected risks.
Expected, only expected. But what about the impact of illness? Whether the illness will lead to his death, for example, or will lead to consequences very dangerous to his life?
It may lead to that state. Doctor is a duty.
Okay. Can I have your comment, please?
I do believe that he must inform.
He must inform.
Unless otherwise he's a minor or a mentally challenged person.
Yes, these are exceptions by the law.
Otherwise he has to inform.
Okay. What about doctor, please?
I believe that the doctor has to inform the patient about the major risk, plus minus the minor, as he mentioned. Yes. So cover like all possible risks.
Thank you very much. What about you, Jill?
I think the same. Like the doctor should give the side effect of everything that should be had most of the time.
Thank you. I think that regarding question number two, the doctor is not under an absolute duty, which means in all cases the doctor should inform the patient about the dangerous risks of his illness. The criterion is simple. The criterion is the result of informing the patient. Will this be detrimental to his health or not? Is this necessary for him to know, and this will be for his interest or not? The second question, of course, a doctor, in my point of view, is not under duty to inform the patient about the unexpected risks. He should inform the patient only about the expected risks. If an unexpected risk happens, the doctor, I'm sure, will not be held accountable for failure to inform the patient. Question number 5. Informed consent. According to Article 5, Paragraph 1, a doctor may treat a patient only with his or her consent, except in cases of urgency where it is not possible to take such consent, or where his or her illness is contagious or threatens public health or safety. So, the rule here is not absolute, but is relative, which simply means that a doctor, as a rule, has to obtain the informed consent of the patient. But there might be situations where the doctor can do without this consent. Let us see some of these situations. What should the doctor do if the patient refuses treatment from a disease which is likely to cause his or her death? What if the treatment failed and the patient died? Will the doctor be held accountable? Let me tell you this real story. It actually happened. I was giving a course on legal advice, and one of my friends who is working in Dubai Health Authority, in the legal department of Dubai Health Authority, came to ask me. He said that we had a patient who is hit in Iran in a car accident, and he suffers from severe injuries, and he needs very immediate surgical operation. But to conduct the surgical operation, we need to give him blood transmission. He insists that he will not take blood transmission because according to him, this is not allowed in his religion. So he insists not to take blood transmission. When they asked his relatives, they also insisted. They said that they would prefer that he dies and not take blood transmission rather than live with blood transmission. Now, the problem was severe. The problem was critical. If the doctor operates on the patient and the patient dies, the doctor will be responsible because he didn't take or he acted against the consent of the patient. On the other end of the spectrum, if he refused to intervene and left the patient absolutely will die. So the doctor also may be blamed in this situation. What do you think the solution can be in this case? Ma'am?
There are solutions. There are fluids available for the people of Jehovah's Witnesses. And I think we should have them available here. And that can be given. That's what is used in the West. We were using that in Ireland.
So the doctor should intervene?
No, not giving blood, but there are other fluids which can be given to these people. Yeah.
If the blood transmission is essential?
No, really, we have seen cases and we have given and it works.
So you can do the operation without giving blood?
Yes.
Okay, so this will be a good solution. But let us assume that you don't give him blood transmission and he dies. You operate on him and you don't give him blood transmission and he dies. Yes?
You need to document his refusal.
Yeah, that's what I said. Documentation.
Yes.
Because you need to act upon his wish, especially that the family is also in consent with his wish. So that means that you need to document this as a first stage. And then if there is any medically possible procedures that can be done, then they can try their best. If not, then the hospital and doctors shall not be held liable.
The best solution is to measure the possibilities. Possibility number one, if blood transmission is not given to him, what is the percentage that he is likely to die? Yes. Possibility number two, if we conduct the operation and he dies without his consent, will the doctor be liable or not? Possibility number three is about his condition, health condition. If we do not conduct the operation, will he have a chance to live or not? According to these possibilities, we can decide whether to intervene or not. And in all cases, I think that you will have to intervene if there is a risk to his life. So this is the important point. If there is risk to his life, you should intervene even against his informed consent. Exactly. Right. Yes, Stephen.
Yes, thank you. I'm sure you were just about in your next slide to come to this point, Alan, so please forgive me, but Article 9 of the Medical Malpractice Law, Federal Law number 8 of 2010, says patient's life may not be ended for whatever reason. Now, I know this is not quite the situation here, but if the situation is that that patient will die if you don't intervene, I think that's analogous to the situation where you're effectively allowing the person to die at his request. And I think Article 9 would basically should guide practitioners, which is patient's life may not be ended for whatever reason, even upon their request, or their guardians or custodians.
Yes, this
So
answers this.
my advice would be err on the side of caution, and if someone tries to sue you for failing to let them die, what would be their damages? What is their loss? So it may be that nominally you are technically in breach of the rules for consent, but they've suffered no loss because of it.
Thank you, Steve. Thank you. Now let us skip the other questions because I will stick to my schedule. But there is a very important question. I think it is question number 10. Let us take this question. Doctor's duty not to reveal a medical secret. Can you define the medical secret, please? What do we mean by a medical secret? What does, yes, please?
Anything between the doctors and
Anything said between the doctor and his patient. Is it necessary that this information, or the facts, or the words said between the doctor and the patient should be related to the doctor's work or the patient's case or conditions? Is it necessary that there should be this link?
It has to be linked to the patient's health or what the doctor is treating the patient for.
Thank you. What if something is published in the newspapers, for example, about the patient's case, or the doctors knows about the patient's case, not from the patient directly, but from any other source? Will the doctor still be under duty not to reveal the secret?
I would say if it's publicly known, it's not a medical secret anymore.
Is my question clear? Yeah, let us repeat it again. If the kind of information which the patient told the doctor is already known to the doctor from other sources, will the doctor be still under liability for revealing the secret? Yes. Will we still consider this a secret, Doctor?
Yes. Yeah. Unless this information is shared between a group of doctors or in a meeting to decide about the plan of his treatment or care, or comes up in a meeting, morbidity or mortality, whatever, we should not divulge the patient's confidentiality and secret information to anybody else. Yes.
Okay. Now, the criteria, please.
I do believe that they have to take a consent from the patient for PR. If they're going to release it in the newspapers, they have to take a clear consent from the patient.
Yes.
That's the...
We have an argument on this particular point. On one end of the spectrum, we have those who argue that the criterion should be objective, not subjective. In other words, whether revealing the secret would harm the patient or not. On the other end of the spectrum, we have those who argue that the criterion or that the test should be subjective. In other words, it depends on the patient himself, whether he wants to reveal it or not on the kind of information. Simply, it happened, a patient suffered from flu. And of course, as you know, flu is not something gracing or disgracing or shameful. When the doctor revealed that he is suffering from flu, he didn't know that this will affect his employment. Because in his employment, they do not allow him to suffer from flu or to work while suffering from flu. And in this case, the criterion, the test was subjective, not objective. It depended on the patient. It depends on what the patient says, not on what a reasonable man can find. Doctor?
Yeah, I'm sure Dr. Mahmoud and everybody in this, most of the people, audience sitting here will be knowing about the HIPAA regulations. HIPAA regulations in the United States. Disclosing any information about a patient, unless it's for any criminal issue, maybe the lawyer, I don't know whether the lawyer Dan is sitting with me will agree or not, he is the final authority on that, should not be divulged to anybody unless we have permission from the patient.
Thank you.
I don't know whether it's work here in UAE or not. The HIPAA regulation, maybe you can clarify and the legal expert can clarify. No patient information to be released unless patient gives consent or unless it's for any criminal issues.
A famous case which was held in the French Court of Cassation. According to this case, a pregnant woman went to the doctor with a man accompanying her. And she didn't know that, or she knew, but she wanted to submit herself for medical examination. The doctor said to the man accompanying her that she was pregnant. The woman was pregnant. Later, after 12 days, the woman gave birth. The man, when was told by the doctor that she is pregnant, did not object, but he believed that he is the father. But when the woman gave birth after only 12 days, he was sure that this is not his son, and he denied to be his father. The court refused even to take his statement, and the court said that if it allows him to give a statement, it means that it allows him to reveal the secret of his patient. According to the Emirates law, and particularly Act 28, I'm sorry, a doctor is under duty to testify in the court of law if he is asked to testify. And this is very significant. The words here, if he is called to testify, which means if he is not called, he cannot go to the court and testify and reveal the secret of his patient.